Kaya Stanley, and I'm the CEO of CRMBC, California's only restaurant workers' comp self-insured group. Today, I'm joined by Michael Adreani, a principal at Roxborough Pomerance Nye Adreani, where his practice focuses on labor and employment and workers' comp cost containment. Thank you so much for joining us today, Michael.
Thank you, Kaya. Nice to see you again.
So on the last podcast that we did, we talked about PAGA, which is a nightmare for all restaurant owners right now. And today we're going to dive deeper into PAGA because there's some new things, new legislative things that are on the horizon that we want to make sure that everyone's aware of. But before we start that, Michael, tell us a little bit about you and your practice.
Well, I'm a member of a firm in the Los Angeles area. I've been with this firm since I got out of law school, so I've only worked at this one place, and it's been a pleasure to do so. My firm specializes in two main areas, the first of which is general labor and employment law. So we deal with this PAGA statute on a daily basis, as well as advising employers like your restaurant clients on day-to-day management of their labor issues, wage and hour laws, best practices, handbooks, manuals, arbitration agreements, and that kind of thing. And our other practice fits actually pretty nicely with the employment practice, which is we represent employers like restaurants in disputes with their workers' compensation carrier. Now, we're not workers' comp attorneys fighting it out at the board. What we do is we represent the employer in disputes directly with the carrier. So this might involve the mishandling of claims. It might involve over collateralization. And that involves also third-party administrators. So in a self-insured context, we have had disputes with or corrective action against some of the big TPAs out there for mishandling claims and dropping the ball sometimes. And it happens, and that's what we're here for.
Well, we're lucky that we have you on our side because you actually are our attorney. So we're glad that you're not against us. Let's talk about PAGA, this nightmare of a law, the Private Attorneys General Act. First, let's start with giving us a high-level overview of what this law says.
Sure. One of the words you just used, the Private Attorney General's Act, the word private, I think, if you delve into what that means, that explains a lot about this law. It means that in order to sue your employer, you get deputized as the private attorney general. So an individual, an employee, may say, I worked here. I believe that there was a small technical violation of my labor code rights, which could be having a chair or or having the wrong temperature or something could be major too, like missing overtime or missing meal breaks and rest breaks. But a technical violation of any sort could deputize that employee to sue on behalf of all the employees, and not just the current, but the former employees over a certain period of time. So that could turn a small technical violation into the equivalent of the dreaded class action on behalf of, could be hundreds and thousands of employees. And you may think, as we discussed before, that you have an arbitration agreement that's supposed to shield you from our class actions. But of course, PAGA, in case after case, has been excluded from those protections on class action. So if you have an arbitration agreement, you can get out of the class action. You cannot get out of PAGA in California. And I can go through all the cases if anybody cares to hear about that. But that law has been clarified, and we don't think there's any going back. PAGA, as it is currently constructed, it is immune from arbitration agreements. So you're going to be in court, and you're going to be facing penalties, attorney's fees, and paying your own lawyers to defend yourself.
And one of the most maddening parts about this law is that the money doesn't even end up getting to the injured worker most of the time. It's a game that attorneys are playing, trial attorneys are playing to attract and find these employees who are willing to file these lawsuits, but then all the money is going to the law firms.
There's a great example of that, Kaya, which is there was recently a settlement in the range of about $100 million The attorneys who prosecuted that case got $21 million. And because the PAGA action was so large over so many employees, the employees each got $108. So the employees themselves, 108, the lawyers, 21 million. And that's because attorneys' fees are mandatory in this private attorney general world. It takes the action away from the state and gives it to the private individual. And let's be honest, it's really the attorney driving this.
Right, right. But we have a more positive conversation to have this time than we had last time, because there are some legislative changes that we were hoping were on the horizon, and now we think that it's probably more likely that they're on the horizon. Why don't you talk to us a little bit about that?
Sure. You know, the last time we spoke, I felt like I was just giving you a massive horror story, but I did end it by saying I think there might be some good news. And so that's the nice segue to this, which I hope is good news. There is actual legislation which will be on the ballot this year, 2024, November 5th. There is a ballot measure to entirely replace PAGA. It is called the California Employee Civil Action Law Initiative. And your listeners don't have to do this, but I printed it out and I read the whole thing. I don't recommend it, reading any law, but this law, if it passes, is not an amendment to PAGA. It is not a tinkering. It is replacing PAGA. PAGA will no longer exist. And earlier we emphasized the word private. The main thing about this new law is that it would eliminate that word, private. It takes these actions, removes them from the private attorney general, and brings them back to where they were before PAGA, back in 2003, which is the state should be the one prosecuting these claims of the state. It makes the Division of Labor Standards Enforcement, the DLSE, would have to be the plaintiff now on behalf of the employee class. Now, what does that mean? It means that there are no attorney's fees. It means that there's no reason to use this split they were using and they currently use in PAGA, where 75% goes to the state and 25% only goes to the employees. Under this new law, any PAGA award that the state achieves, 100% of it will actually go to the employees, the people who were, you know, in theory, harmed. It will also encourage more righteous suits. There aren't attorneys looking to cash in on an unwitting mom and pop employer or restaurant. This is the state who has to decide, are we prosecuting this or not? Was it willful or not? Is it worth it or not? So the benefits of the law are to eliminate the incentives for frivolous suits on behalf of employees, attorneys, and also to benefit the employees by directing the money that is received to those employees who were harmed or who had suffered violations, let's say. And there are, you know, let's be honest, some employers do these things, and sometimes it is warranted to go after them. This law says the state should be doing it, not the private attorney general.
Is there any relief on the horizon for people who are currently in PAGA lawsuits if this gets passed in November, or?
That's a great question, and the answer is probably no. Most laws are prospective, and having a law that is retrospective is very rare, and I certainly didn't see it in this one. So if this gets passed, and you know, I would encourage you to reach out to your groups and all the different wonderful social media ways that you do, and you know, let's try to get it passed. I think it should be for both the employees and the employer. It's better for both, I believe. But there will be a lag time. It can go into effect, you know, in 2025, but it likely won't change existing PAGA suits.
And some of the, like you mentioned that one, I was talking to someone earlier today, these can be catastrophic for a smaller restaurant owner, and even for a bigger one, because then the award is just bigger. But they're really quite egregious.
And not only that, they are 100%, they can be egregious, and they're also repetitive. So you have attorneys who are quite aware of the fact that the last time you got sued under PAGA was a year and 1 day ago. It's time to do it again because that statute of limitations is only a year. You can only settle a case for the violations that have already happened. There is nothing stopping an attorney from finding somebody and 1 year later saying, and here's another year of so-called violations. That's one of the big problems with PAGA. The idea being that the state, if the state were re-deputized to bring these lawsuits, they wouldn't be so incentivized to come after you every year. And the law also includes some provisions and some resources for employers to make corrective action and get out of these things.
Yeah, it's so if we're talking about takeaways, one is obviously to tell people to vote in November. Yeah. But a second is there any chance of getting more relief? Should people be reaching out to their representatives now to get more into this law to protect them, or is this train already out of the station?
There's always things you can do. And if we can anticipate this law coming into existence, you're going to even want to be even more diligent about your policies and procedures now so that you don't, because that's something that the labor commissioner and the DLSE will be looking at is whether you have valid policies and procedures. So that's something you can do now. The get out the vote is certainly something you can do now. This bill is sponsored by some big groups, some unions, not unions, unions would be against it. Chambers of commerce, that kind of thing. And they do have some money and some legs behind them. There will be an advertising binge on this one. If you remember, I believe it was 2 years ago, the issue about whether Lyft drivers were going to be independent contractors or not. How many commercials did we see? I think it's going to be like that. And I haven't seen it yet, but there will be the unions and I believe the consumer attorneys, the plaintiff attorneys, trial attorneys will certainly get behind opposing this bill. And they will, I can articulate some of the arguments that they'll make because I think it's important to know that. One of them would be, look, the state's not going to do this. We're doing the work. The state is going to maybe not have the resources, which is why PAGA came into existence in the first place. The state had the ability to go after people, but they didn't have the power, the staff and the money. So the counter argument to that is, well, for the last 20 years, 75% of all these settlements have been going to the state. That's use the money. Now you can use it. You're on better footing now than you were 20 years ago. And there are some studies about that that went into this law saying, look, you can do it. And you can fund these types of lawsuits. The other thing, by the way, is that the penalties will be more under this new law. This new version of PAGA without the private is going to have, in some cases, double the amount of penalties. So it's not like a get out of jail free card for employers. There are some parts of this law that have bigger teeth for those who are willful, those who are intentionally treating employees badly. They're going to be punished, and they should be. And those penalties will skyrocket even more. But the employee will get the money in those cases.
The thing that is the most frustrating that we see, though, is when an employer is trying. They're not trying to do anything wrong. They believe that they're following every law, and there's some gotcha because there's a million laws that they have to keep track of. And the ones that are these gotcha and then it just costs them millions of dollars, those are the ones that are the most aggravating.
For sure. And this new law would give a discourse with an attorney for the state who doesn't have a dog in the fight financially and who will listen to you. That's what I believe. I believe that the situation you're describing where it was really a technical violation. Look, the pay stub machine accidentally printed too many digits of your social security number. We fixed it. You don't need to come after me for millions of dollars. We fixed the problem. Maybe we can make people whole if they suffered an actual violation or a privacy breach or something like that, let's work with you. That's not always what happens when it's a private attorney general. Somebody looking to line their own pockets and get a big attorney fee award. The state won't be doing that.
Right, right. So before we close on this one, real quickly, since there's still the restaurant owners still have to be concerned about this and still need to be doing things to avoid this. Give me your top 3 pieces of advice of what they can be doing. Like I know I asked you last time, if they had done these certain things, how much it would have made it easier for you to defend them?
Policies and practice. Make sure your handbook is up to date. Your handbook has to be up to date, has to be distributed to everybody, and have a record of it. This employee signed the handbook. It says right here, we have valid policies. It says, I will adhere to those policies. I will take my breaks. Number 2, if you find a violation, and you will, it's hard to comply with all of these laws. Pay the penalty, pay the extra wage. If you find somebody who's missing a meal break, pay the premium. Because and that will show up on the pay stub. Make sure it shows up, because then you can show the state or any private attorney general, that should work that way now, by the way, is look, there is no harm here. Somebody missed a break, somebody got their premium.
Michael, thank you so much for being here. I really appreciate this conversation and you sharing your expertise with us about this absolutely, again, nightmare of a law.
Always a pleasure, Kaya, anytime.